Okay, we're live.
Hello, hello everyone. Welcome to Ask the Expert. I'm so super excited. I guess excited every so often when I'm with people that I'm really excited to be partnered with. And today we're here with a very wonderful colleague. I was call her a friend. I'll call her a blessing to my family, to yours truly, Nicholas, who is an impetus for what we do with my goal. So we're on Ask the Expert, and we do this on a monthly basis because the goal here as an organization is to support families facing autism and other intellectual disabilities throughout their lifespan. And our vision has always been to create opportunities for people to learn and grow and learn. And that's really, 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 really important to me. I think when we know, we feel empowered and we use our voice and we can advocate. So for those of us who are in the special needs world, where we have our kids that need individualized education planning, it's so crucial that you know what the rules, what the rights, what they all mean, so that you know how to use your voice. So this year, I was thinking about some of the topics that we can do. And I turned to my dear colleague Hillary Freeman, who's not new to my goal. She's actually a family member. She's traveled with us to Ghana, to Haven International. We went to Liberia together. We did a whole talk for a whole country. And you know what I love about this woman is that she's to the point, and in the state of New Jersey, she's a force to be reckoned with. There are moments where, when I don't know what to do, I was just like, okay, let me call Hillary. And whether it is dealing with adult services, is dealing with school-related issues, is having her speak to a family member or two, she's always there. And, I'll have her introduce a little bit of her journey in this world, because I think it's pivotal for people to know is that she gets it. So this is not just a professional thing. This is personal too. So I asked her to talk today on the educational rights and advocacy, understanding IEP, which is individualized education programs, and the 504 plans. So she's here. She's given her first Sunday afternoon. So Hillary, thank you again and again for all you do for us. We appreciate you and we want to welcome you. So for those of you who are joining us on Facebook, if you have questions, do post it and we will be able to offer it to her to answer your questions. And we are so thankful that you're here again with us. So Hillary, welcome, welcome, welcome.
Thank you so much, Dr. Genevieve, and thank you everybody for having me and being here today. As Dr. Genevieve had mentioned, my practice stemmed about. Started in 2011, but I've been practicing for way longer than that. And we advocate for individuals with special needs across their lifespan. So that includes special education and 504 accommodation services. It includes guardianships, SSI, Medicaid, wills, special needs trusts, and adult services, all for individuals with special needs. I always make the joke that we discriminate against the neurotypically developing population because in order to be a client of the firm, you have to have a family member with special needs. Again, thank you so much for having me today. I have a brother with autism. He is 52 years old. We think he's about a 2 year old, although I think he understands a lot more than we give him credit for, probably. And he has been living in a supervised apartment since COVID. Prior to that, he lived in a group home for I think about 15 years. And he's doing great. He has a one-on-one in his supervised apartment. He is retired at 53. He goes into the community. He has different events with support. And he's loving life right now, which is really nice to see. And he actually just got an award for being in his program for 30 years. So So we had that last weekend. So with that, well, comes a lot of experience, and I've been able to see how the world has changed over the course of about 20 years that I've been practicing, and how the world has changed, has how the research has changed, how our advocacy efforts have changed and evolved mostly in good ways. And I'm here to talk to you about that today. So with that, I'm going to talk to you about the overviewing of special education law, and we're going to talk about the Individuals with Disabilities Education Act and Section 504 of the Rehabilitation Act. This is an overview. I'm happy to go into more detail in another conversation, another presentation, or if you just want to call and you have any questions, I'm happy to answer any questions that you have. But this is really intended to be an overview. With that, I encourage you to ask as many questions as you want. I love getting questions along the way because I just want to make sure that you understand the material. Um, so, so to start out with, we're going to talk about Section 504 of the Rehabilitation Act. And the reason that you might see, the slide is a race, it's not really intended to be a relay race, but more to talk about how Section 504 is an anti-discrimination statute. And we want to try to make sure that everybody is getting equal access to their education. So they're just because they have a disability, they're not being prevented from getting access to their education and learning purely by reason that they have a disability. They're entitled to reasonable, if they have a disability that substantially limits a major life activity, then they could be entitled to accommodations and modifications in order to help level the playing field. And that is, and so some different accommodations that one might be entitled to if they're eligible for under Section 504, it could be extended time on exams. It could be an extra set of books as long as books are alive and present. It could be that if they can't get to school, maybe they're getting remote instruction. I do recognize that school districts are giving a harder time about giving instruction remotely. But under Section 504, if a child needs a remote instruction in order to access and benefit from their education, the school district would have an obligation to provide that. Sometimes they are entitled to a one-on-one paraprofessional or a shared aid. Sometimes they get frequent breaks. They could also get specially designed instruction, special education. This language that's before you is directly from Section 504 of the Rehabilitation Act. So a lot of people think that Section 504 is just an accommodation statute where you can only get minimal things, like some of the examples that I mentioned. But I'm also really want to highlight for you that the students can get regular or special education and related aids and services if it's necessary to meet their needs as adequately as the general education population. That's a common misnomer, so that's why I'm emphasizing that for you. If a child is eligible for an IEP, they could also be entitled to the protections of Section 504. You don't need a 504 plan and an IEP. The IEP often incorporates the accommodations and modifications that would be provided through Section 504. Okay. That's really so that's a common question that we get, and but if your child has a disability that substantially limits a major life activity, they can't be discriminated against by virtue of their disability. Where do we often see this? This could be happen in school where a student might not be able to get to a certain class because it's on the second floor and they're in a wheelchair and there's no elevator. That could be a situation in which the school district might need to move the class. It could be in an aftercare program where the school will say that the aftercare is not a school sponsored place, so they have no control of how the supports that are provided in the aftercare. However, if there's a relationship between the district and the aftercare provider, or if it's happening on school grounds, or if all of the students go from one district go to this same aftercare program, then arguably the school district would be responsible for providing accommodations and modifications. So students with special needs, such as autism, could be in that program, and in spite of behaviors. They might need a one-on-one in the aftercare program to access that, or the before care program. And that would be something that the district would be obligated to provide under Section 504 of the Rehabilitation Act. Um, the last piece under Section 504 that usually it doesn't come up very often, but I know it is a concern of a lot of parents, is that if a teacher shouldn't be afraid of advocating for a child with special needs. A parent shouldn't be afraid of advocating for a child with special needs out of fear of retaliation. And Section 504 confirms and they say that if a child is retaliated against, or a family member is retaliated against, or a teacher is retaliated against by virtue of their advocacy efforts, then there could be a Section 504 violation. Okay, and they would be entitled to damages as a result of that. The next big statute is the Individuals with Disabilities Education Act. And if your child has an IEP, you're probably somewhat familiar with this statute. Not every word, it's a long statute, but you are probably familiar with it because it does fall under the IEPs fall under the IDEA. And the IDEA is what we call an entitlement statute, right? So you have Section 504 that says your child can't be discriminated against by virtue of their disability. But on the other hand, the IDEA says that students who have a disability that interferes with, excuse me, it adversely impacts their ability to learn and they require specially designed instruction, they would be entitled to special education and related services under the IDEA, and that's through an IEP. Welcome to Acronym City, by the way. So I hope you're following along with this. Okay. And for those of you who don't, Genevieve, I forgot to tell you, I have a card now, a bookmark that it was my middle of the night project with all of the acronyms. So anyone who wants that, just to understand the different acronyms, by all means, we're giving them out just make it easier for you. So as I mentioned, if a child has an IEP, they have a disability such as autism, dyslexia, processing challenges, ADD, ADHD. These are just different examples of disabilities, but by no means are we limited to those disabilities. It has to adversely impact their ability to learn. When we're talking about those skills in which it adversely impacts their ability to learn, we're focusing on learning skills that will help identify their unique needs and prepare them for further education, employment, and independent living. Okay, because that's the goal of the IDEA, right? So these are the areas that the IDEA focuses on. If your child's disability interferes with that, their ability to make progress in these areas, they could be entitled to special education and related services to help them achieve these goals. Okay. And those particular and some examples of that would be academics, social skills, emotional development, functional life skills, and appropriate behaviors, because these are skills that are necessary to prepare them for further education, employment, and independent living. I think we would all agree that students who can't go into a mall and jump up and down in their workplace. If they're working in a mall, or if they're working in any type of environment, jumping up and down and having excessive behaviors is not going to be favored by the employer. So instead, if that's something that they struggle with because they're having trouble expressing whatever they're trying to communicate, then under those circumstances, we want to teach them the appropriate ways of communicating, right? So that's an important skill to develop, and that would then go into the IEP. Okay. So any student with an IEP is entitled to a program that helps them make progress appropriate in light of their circumstances. So for a student who might have a very high IQ that we know of, and I say that because not all of the psychological assessments are completely accurate. Not all of the IQ assessments are completely accurate. But if a child is making progress academically, but they're struggling really socially and emotionally and behaviorally, then their goals have to be written in a way to address the areas that they still need to work on. But we don't limit their goals, right? We don't limit their goals and say, well, that this is all they need to learn. We want to look at what their potential is, right? If a student can learn one thing, that means they can learn. And we just have to figure out how they need to learn in order to make progress in their program. And so the IEP needs to be designed around making sure that that happens. So how do we do that? We have the basic section of the IEP, which is the first page, which is just an overview of the child's program. It usually includes demographics, name, address, maybe their disability or their classification category. Sometimes it includes an overview of their program, so what class they're in, what related services they're receiving, speech and language, OT, PT, if they have an aid or special transportation, it would reflect that. Other times that's later in the IEP. It just depends on your district and the program that they use. But then you have the present levels of academic and functional performance. And that's the baseline of the IEP. And this is, in my view, is the most important section of the IEP, because this is the part where you talk about what your child is able to do and what their challenges are. This is a really important section that I think should be detailed to the best extent that you feel comfortable with. And teachers can include commentary on how the child is performing. Parents, you should be able to include commentary on what you believe your child's needs are and what their strengths are. If a district or the child study team comes back and tells you we don't want to put that in this section, then you can write your bio of your child and the description of what you want to be in the IEP, and you can ask to have that included in the parental concern section. So that is a way of getting your information into the IEP, even though it's not in this section. So, and I find this very beneficial because you're able to talk about what your child is able to do now. So if you say, my child can count from 1 to 20, I don't care what grade they're in. This is just for the sake of this example. If you can say that they're counting from 1 to 20, in 3 years from now, you can go back to the IEP and see, compare where they are now to where they were 3 years ago and see how much progress they've made. You can do it year by year, but I'm just saying it's a good source of comparison. It's a baseline of where your child is performing and what their needs are. Okay. So you have the present levels, you have the goals at the end of the IEP, and that's where you expect your child to be in a year from now. And then everything else in the IEP are the services and supports necessary to get from where they are now to where you want them to be in a year from now. Okay, so any questions so far?
Yeah, I have a question. So
Mhm.
what I'm hearing you say is that there's almost like a template in which, or format in which this document should be set up. And because sometimes what I've seen in the past is that there's so much information that is over our heads, and that you look at this document is overwhelming. So the need to pay attention to specific segments of it, it's important. It's what I'm hearing you say. So within the section, if I heard you correctly, I'm trying to take notes because this is like all these years. You think I'll know this? This I didn't know. I knew there was templates, but I just didn't realize that the background in terms of the overview. And then you get into the present level. I think you guys call it PLEP or something. Um, and then you're talking about the goals, and then also obviously the services that will take you there. And then the segment that you talked about was the parental concerns, the component that's in there. So what are the key things? So one, the question goes back to, is there a template? that needs to be followed? And is that part of the law of how the IEP, or is that state based?
So there's not a template that needs to be followed in this. Every IEP has a certain amount of sections, and all of these sections are consistent. There are some exceptions, deviations from it, in that, like in Pennsylvania, they also have an extra form called the Notice of Recommended Educational Placement.
Mm.
And so different states have different ways of proposing the program, but every program has written notice. Every district across the country is required to give written notice under the IDEA of what they're proposing. Okay, does that make sense?
So if you say written notice, that's the letters that they'll send to you to say your child's placement. Is that different from the
On the district. So the written note, it has to be written notice. An IEP can be written notice. A
um,
letter can be written notice. The in New Jersey, the written notice is generally in the form of an IEP or a notice that they intend to amend the IEP. Okay. The initial IEP can't go into effect without the parent's signature. So that is required. They can propose it in January. If the parent doesn't sign it for another year, it does not go into effect during that time, right? It has to, the parent must sign the IEP or consent to the IEP in order to make that happen. If after the initial IEP, the district proposes a subsequent IEP and that through a meeting, that can go into effect regardless of whether the parent signs it. Okay, so that's really important. Sometimes you'll hear that you have 15 calendar days to sign the IEP or file for due process. The 15 days, I want to say, is also a misnomer because New Jersey has been found to be in violation of the Individuals with Disabilities Education Act through that 15 days, 15-day limit. And so, hold on, I'm sorry, one second. So you really have to, the district is really required to propose the IEP, give the parents a reasonable time to consider the IEP. And then if they say it's going to go into effect in 15 days, then the parents have to file for due process within the 15 days in order to stop that from going into effect. Conversely, if the district proposes an IEP in February and for the following school year, then the parents have until the following school year to consider the IEP. They have to just file before the next IEP goes into effect. Does that make sense?
right? So what I'm hearing, you would think all these years I should know this by now, and I'm just trying to be hopefully, hopefully breaking it down for family that's listening. So when you use the word due process, what does that mean? File due process. And then the other piece, what I'm hearing you say is that the initial IEP needs the consent or the signature. The subsequent ones you don't, but it can basically, once you've had the meeting, they can go into effect. What if you don't attend the meeting?
So if you don't attend the meeting, then the district is required to notify you, and make reasonable efforts to have you be a part of the IEP meeting. So they have to make reasonable efforts. If they don't make reasonable efforts, then they would be in violation. So they have to document their efforts to contact you, to incorporate and make it the accommodations necessary to help you to allow you to be there. If you don't respond, you don't respond, then if after the initial IEP, it can go into effect. If you don't, the only time that you have to file for due process is when you don't want that IEP to go into effect. So if a district, let's just say, a student is at Douglas and the district wants to bring the student back from Douglas, then under those circumstances, if you don't want your child to come back, then, under those circumstances, you file a petition for mediation before that IEP goes into effect, and it can't go into effect. They have to keep paying for Douglas until the dispute is resolved.
All right. So, and I think, Ronka, you have a hand up for a minute, but I want to go back to that comment. So when you file, you have 15, you said we have 15 days before the IEP takes effect. 15 calendar days, business days, you're
It's
muted.
calendar.
Okay.
Yeah. But again, this is, I want to say it's a misnomer because that was the law for several years. And then the feds came in and said that that can't be the case. So you're not limited to the 15 days. You have to just file before the next IEP goes into effect.
Aha.
Okay. And they did not make a huge announcement when that came out. But practitioners in the area are familiar with that, but they didn't make a huge announcement. So a lot of teachers will say, parents, you have 15 days. And it's not always accurate. If the IEP is not going to take effect for 5 months, you have 5 months to consider the IEP.
Oh,
Okay.
wow.
So you have, so essentially, I'm going to stop sharing my screen for a moment so you can, so I can talk to you. So essentially, and this is a pretty, I think a pretty important point. If you don't want that to go into effect, you have 15, you have maybe 15 days. If it's gonna, if the district says we're putting it in effect in 15 days, you could have 3 months, you could have 6 months, okay? But that's, but, and it's also, but if the, I'm just gonna say, it's also from, it's before the next IEP goes into effect, but if it's a draft IEP versus a final IEP, the 15 days doesn't count, right? Because you're still working with the district to try to resolve the issues in dispute. So I'm not trying to confuse you. The whole idea is to get the parents to working together to help reach an agreement, right? So there comes a point where everybody just says, look, we're on separate pages here, then your method, as a parental right is to file a petition for mediation with the Department of Education, tell the Department of Education, look, the district is proposing a change. I disagree with this change. Here's why I disagree with this change. And I'm asking you to order the district to give us whatever you're looking for. Okay. And then you'll have a mediation or a resolution session, which are both informal meetings to resolve the issues in dispute. If it's still not resolved, it will go to a settlement conference with a judge. And that is another informal conference to resolve the issues in dispute all over Zoom. And then if it's still not resolved, it's transmitted to the Office of Administrative Law for a hearing. And that's where you put on witnesses to say why you're right, and the district will put on witnesses to say why they're right, and you leave it up to a judge to ultimately make the final call. Okay. And if you, in this case that I mentioned before, where if your child is at Douglas and the district proposed a change to in-district programming, and you filed within a timely fashion, and you filed for your petition for mediation within a timely fashion, your child is at Douglas while all of this is going on. Okay. If you missed the deadline and the IEP went into effect, then your child is in the proposed placement while the adults are fighting it out in court. Okay. That's called stay put.
Oh,
Where is your child during the pendency of the dispute?
got it. Okay, this is very helpful. Veronica, you had a question?
Hi, good afternoon. Can you hear me? Sorry, I'm
Yeah,
driving, but I can't answer my question. So, yeah, so I just want to know, I don't know if you've touched on that or probably I missed that. How many days prior to the meeting are you officially expected to have the IEP?
document.
You're not
Like a draft.
the district is not required to give you a draft in advance of the meeting. It's a nice thing to do. It's a courtesy to make you feel like you're an equal participant. They're not
Okay.
required to give you a draft of an IEP ahead of the meeting. What they are required to do is if your child has been evaluated recently, like either initial evaluation or reevaluation, then the district is required to give you those evaluations at least 10 days in advance of the meeting where you're reviewing the evaluations together and discussing whether your child continues to be eligible and you develop an IEP.
Okay, so if they're not
Oh,
required to give you,
oh, sorry.
no, go ahead, clarify.
Okay,
Go
so to reiterate what you said, it's only when evaluations are completed that you're required to have the the draft 10 days prior to the meeting, correct?
Oh, no, you're not required to. There's the difference between the evaluations and the draft of the IEP. So your child, okay, let's back up for 1 second. If you're in order to determine whether your child's eligible for an IEP, they would undergo evaluations. Usually it's a speech and language evaluation, an educational evaluation, a psychological evaluation, maybe a social history, maybe a neurological evaluation, maybe a psychiatric evaluation or OTPT, and the list goes on. Okay. If it's an initial evaluation, the district has 90 days to complete those evaluations and then meet to determine whether your child is eligible for an IEP and then develop an IEP. Okay. If it's a reevaluation, the district is required. So by reevaluation, I mean that usually it's about 3 years have passed, and the district is conducting another evaluation to determine whether your child continues to be eligible for an IEP. And though under those circumstances, the district has 60 days to complete the evaluations and develop an IEP. After those evaluations are done, so it's usually on average once every 3 years. After those evaluations are done, parents get a report of what the results were of those evaluations. Though that report is required to be provided to you 10 days before the meeting. It may or may not include a draft of the IEP. It will likely just include the results of the evaluations. They're called evaluation reports. That makes sense? I know.
Okay. Yeah, that makes sense.
That makes sense. So
Thank you.
let me ask you this. That was a great question, Ronke, because I was also under the impression that you're supposed to get a copy of it before the meeting. But could you request for the draft beforehand in writing, just so that in fairness, you can say, I don't want to come to a meeting where everybody else have had an opportunity to put their inputs in beforehand. And here it is, I know the meeting is where we can discuss it, but how do we have a fruitful meeting if I don't know what the content of the document is going to be?
So you can request a draft of the IEP in advance of the meeting. The district can say yes, they can say no. If they say no, they'll say you'll have 15 days or however long afterwards to review the IEP and answer any questions. And you have a right to request another IEP meeting if you have any more questions. So if from a practical sense, it makes the most sense for them to give you a draft of the IEP so you review it together and you can prep for the meeting just like everybody else. But they will say then that they're being accused of predetermining the program. So they're sometimes afraid to give it to you. So sometimes, but you'll say, won't hold you to it. We just want to get a copy of the draft IEP that everybody else has. And sometimes again, they'll give it to you, in which case that's great. Other times that you can review it during the meeting. And if you have other questions, you can, again, ask for another IEP meeting, right? You can always do that. And it's not efficient for them, but that's something they could have avoided if they gave you a draft ahead of time.
Well, I guess I'm lucky because, sorry to cut you. This is Patricia. They never deny me. Even the one that my son had this, I think a couple of months ago, they sent me a draft to read over. If any changes, I have 15 days to return, sign and return it. Every time they never deny me a draft. So I don't know what district that got. They never, since my son having IEP since I think second or first grade. They never deny me a draft because they want me to take a look at if I need to have some changes, modification, I have the right to do it. So, but I have 15 days to sign it and bring it over.
Right. I think that's amazing. I love when I hear parents say that the district worked with them and they provided a draft. I love that because it really means that they're taking your input and they care about your input in developing the IEP. I can say that's the case for every district. So under those circumstances, that I would probably approach it a different way. And it's when the law is either ambiguous or it doesn't provide for something, then it's generally districts apply apply things differently, and they have different policies on how they're going to hold their IEP meetings. Sometimes they're right, sometimes they're wrong. It's just the way it is. So under those circumstances, if a parent is denied a draft, the way that I would ask for it in advance. If they say no, if you need extra processing time, then you might be entitled to that accommodation of getting a draft ahead of time. Um, or you can review it with them and then ask questions or have another IEP meeting after you've had a copy of the draft.
Right. So given the draft does not take away the need to have the meeting though, because Pat, I heard you say you have 15 days to review it and sign it, but you're supposed to have a conversation about it, or is that not accurate statement?
You're definitely supposed to have a conversation about it. Yeah, so absolutely. So if you haven't had a conversation about it, then you should
I'm
be at
sorry.
a meeting.
Yes, during the IEP meeting is when we have the conversation and they explain it to me and they say if I don't understand it, they'll give me the draft to take it home, read over it,
Mhm.
ask someone, and I have 15 days to sign it. Or if I would just say I'm just be blessed. Because they even when I don't have the time, 15 days, the case manager will ask me if I need extra time. Like the last one that we did right now, there was a lot of changes that was done in there. So she asked me if I need more extra time to do. And I said I did. I did. So I spoke to somebody about it. So I was able to understand and just give it to them.
You're not required, also, you're not required to sign every IEP. And I don't always know that I would sign the IEPs. You're required to sign the initial IEP to have it go into effect. If if the district is changing a program that you support and you've been asking for and they give in, or they I don't want to say give in, they work with you and they agree with you, you can sign it. If you're not sure if the IEP is appropriate, I wouldn't necessarily sign it. Might just let it go into effect unless you wanted to stop it from going into effect, then you file for due process. And the reason that I'm saying that is by signing the IEP, you're agreeing that the IEP is appropriate. And sometimes as parents, it's really hard to know whether the IEP is appropriate because you're not experts in education. Sometimes you are, in which case I stand back. But if you're not an educator, which a lot of parents are not, then I might just let the IEP go into effect, because and not sign it because you don't know if it's appropriate. So at least it keeps the door open to, you may be challenging the IEP later. The second idea, if you wanted to go into effect and you want to sign it, you can always sign the IEP and then write underneath your signature that you don't know if the IEP is appropriate. So it's the same idea, but it's I don't always know that I don't always feel comfortable with parents signing the IEPs because you don't always know that it's appropriate. So it's just something to think about. There's no right or wrong here. These are just different things to think about. Okay. Another point that I want to really mention is when a child has behaviors, I think it's really important to get a behaviorist involved, a board certified behavioral analyst. I don't, and the behaviors don't always have to be aggressive. They could be, it's at least maybe where this child is, I'm looking to the side, like quiet. Why that seems to be the universal sign for quiet, but they might be distracted or they might just be shy and not engaged. And under those circumstances, you might want to get the support of a BCBA involved, a board certified behavior analyst, to help identify why the child is engaging in whatever behavior they're engaging in, and try to redirect them or get them more engaged in their learning and their educational experience. And special education teachers they're not required to take a lot of specific classes in autism or behavioral analysis. In fact, sometimes I only take one, if any. And so I think it's really important if your child is distracted or if they're engaging in aggressive behaviors or even if they're distracted, it's important to ask for a BCBA to get involved to just take a look at your child, maybe collect some data if it's necessary. And if they believe it's appropriate, if you think it's necessary, perhaps developing a behavior intervention plan to help get the child more engaged in their educational experience in an appropriate way. I think that that's really helpful. That's I think, and it's an area that often is overlooked, for lack of a better term.
So I have a question. Sorry. I'm glad that you brought that up. Because that's the point where actually I am right now. My daughter has a BIP in place, and in our IEP, they are required to provide some form of data because I requested for a monthly data. I want to see how her behavior is going every month. And I attended the back to school, no, it was parents conference last month. And when I saw the teacher, I requested for, I gave her time because September, everyone is new to themselves. They're still trying to get to know each other. And I requested for the data because I actually want to know. I've been receiving report, a daily report, but I'm still not convinced because I want to see the data. I believe in data. So I requested for data, and she brought something up, and she only had like about 5 tallies, one data, just one day. There was nothing to say this behavior occurred in the morning or occurred in the afternoon or during break or during lunch, nothing like that. I just saw the tally marks and I said, I'm not convinced. And I requested to see the case manager. So when I talked to the case manager, I said, I'm not convinced enough because I want to see data. This is no data. You only have October 22nd since school resumed. And the case manager said she was going to contact me and get the BCBA. So then I figure out, okay, I need to send an email because I don't want this to be like a phone conversation, like a one-on-one conversation alone. I wanted something documented.
Right.
So I reached out to the case manager. I followed up. She said she was going to get back to me after she get across to the BCBA to see if she has some report with her. Maybe the teacher is sharing the data with the BCBA and not sharing with me. And then she got back to me saying, oh, she had tantrum 4 times. She climbed the table 2 times. And I'm like, this is no data. Like this, and I asked her, I said, did this occur in the morning, in the afternoon? There should be something. Like they couldn't show anything.
So I think the issue
go
that
ahead.
you're having, the confusion is that, I should say the confusion that you're having is that she is collecting data. She's just collecting the data that's not helpful to you. She's collecting what's called frequency data, which is the amount of times the behavior occurs within a certain period of time. But
Yes.
you want ABC data, which is antecedent behavior consequence. That is what happened right before the behavior occurred. What is the
Yes.
behavior and what is the consequence? So
Yeah.
you're asking for a different type of data than what's actually being collected. And I get why, 100%. I mean, you want to know if your child is engaging in a behavior around circle time. Is it around
Mhm.
class? Is it
Yeah.
around certain type of is it in a certain class? Is it a certain environment? You're trying to get more ABC data generally is more
Mhm.
accurate and gives you more information than frequency data.
Yeah.
So my suggestion to you would be asking for the behaviorist to collect ABC data. And then that will give you the information that you're looking for.
Gotcha. Yeah, because you're right. I only got the frequency and the duration. And that's nothing compared to having, because I want to know the triggers too.
Yeah.
Because sometimes the triggers that we see at home might not be the same trigger that they see in school. So I want to get that to that point where, because they're always giving me good report, but sometimes I see something different in the daily report. And I'm kind of confused, like, okay, someone is saying this, someone is saying another thing. So
Yeah,
thank you for that.
it would make sense why different teachers are saying different things because they might be experiencing different things depending on what's going on in their classroom. I had a client who was very academically very advanced, but but every time the teacher asked for circle time and have the students form a circle, he would hide under his desk and scream. And through frequency data wouldn't have given us the right information, but ABC data does, because we're finding out, well, what happened every time the behavior occurred, right before the behavior occurred. The teacher said form a circle, and we noticed a trend. The behavior, he hid under his desk. The consequence was he got out of participating in that circle time activity because he was under the desk. So we were able to establish that trend by collecting the ABC data. The frequency data just shows once you've identified when the behavior occurs, then you can collect frequency data to see if it goes down, right? But you first have to identify when the behavior occurs and under the circumstances that it occurs before it would be appropriate to collect that frequency data. And it sounds like you're missing that information.
Yes, exactly. Yeah, but actually, I've been seeing the decline in the frequency of the behavior, but I just want to know. I just need some more information on, what has been triggering, um, some of those behaviors.
Yeah, I would be collecting the ABC data. I'd ask the behaviors to do that.
Thank you for that.
Of course. Other questions? So to bring it back full circle to what I'd mentioned before, Dr. Genevieve had mentioned, that we were talking about the present levels of academic and functional performance. To on the example that you just mentioned, once you identify when the behaviors are occurring, it would be a really good idea to put that information in the present level section, because this way, as your child is moving on from grade to grade, the teachers will be able to look at the present levels to say, look, my child doesn't like it when there's a loud noise. And when there's a loud noise, my child might act out and scream and yell and flip over desks. So this way, the teacher is aware of that ahead of time and is not learning as she or he goes. Instead, that they have that information for the following year so they can be prepared and try to plan around that so not to cause your child additional anxiety. Okay, if that change and that it's an issue at one point, but it has improved, then you can note that too. You can say, at one point, my child really did have challenges around in music class or in gym class. And under these circumstances, but now my child has improved with these supports. So, teacher, please continue providing these supports because it's working for my child.
Thank you for that,
Yeah,
Hillary.
thank
I have a
you.
I have a question. So I mean, sometimes we talk to parents and their perception is that just because the child is not making progress, that it automatically means that they should go out of district. Can you just comment a little bit or give some insight on when is it appropriate to really pursue that option versus, because the goal here is to really be in a least restrictive environment as best as we can to give them that opportunity for peer learning.
Right. So Dr. Genevieve just accurately cited the law, which is fantastic. That the districts have an obligation to place children in the least restrictive environment, and that is in the environment as close as much with neurotypically developing peers as appropriate for your child. So there's a continuum that if this child might start, if appropriate, in a general education environment. They could be pulled out for general education and resource room. They could have a special education teacher push in. They could have a paraprofessional push in. If a child is not making progress with those additional supports, and you've tried other supports, such as, depending on the reason they're not making progress, you've tried to get an expert in to consult to find out why your child isn't making progress in that area. If that hasn't worked, then it might be appropriate to go more restrictive. So maybe full-time resource room or full-time autism classroom or multiple disabilities classroom or another self-contained classroom. And then if that still doesn't work, then, or if it's not appropriate for your child, then you might look to an out of district placement that specializes in the area of your child's disability. But the goal really is to bring in as many experts as possible to help figure out why your child isn't making progress in that particular program and provide the supports necessary to do that. But sometimes the children just need more training than is available in the public school district, or maybe the environment is such that's really not conducive for that child, and the environment can't change. Perhaps maybe your child really gets anxious around bells ringing, and in a public school, bells are going off what seems to be every 7.5 minutes. I'm exaggerating, but they go off pretty frequently. And as a result, your child might be in a heightened state of anxiety all of the time. And that's not when your child is in a heightened state of anxiety, they're not learning. I mean, that would feel terrible for that child if they're anxious because they're waiting for the next bell to go off, or they're calming down from the last bell that went off, that they just can't focus on their educational experience. Then maybe that's an appropriate time to talk about, if the environment can't be changed, moving to an out of district placement that has fewer bells. Whereas an environment that's more conducive to your child. There's no set rule as to when your child should be going more into a more restrictive environment. You really do have to look at the individual circumstances for your child and the school district.
All right, that's an excellent viewpoint. So questions in terms of, I know you were doing a presentation, but I think that dialogue is also very helpful. What are some of the trends that you're seeing in terms of the challenges parents are having with districts broadly, especially in light of budgetary constraints? Just because this is a good opportunity for people to buyer beware, right? What are some of the trends as an attorney that you're seeing?
I think that's a wonderful question. One of the trends is that districts are, they're cutting, they don't have a budget, they're cutting their money, their budget has been cut, so they're cutting services. So they might not be providing the education or training to the teachers, or maybe they're having staffing shortages and that children are suffering as a result. You might hear a district say your child doesn't need a one-to-one aid because we want them to generalize their experience from one aid to another, and having the same aid all of the time is preventing that generalization from occurring. That might be accurate under some circumstances. It's not always accurate, as sometimes if your child doesn't have trouble working with multiple people, it's probably not the reason that they're cutting the service. It might be because they don't have the staff. So cutting aids is a big one. Maybe moving into shared aids, moving the instruction to a shared aid model is something that's occurring a lot. I'm also seeing, unfortunately, a lot of students struggling to get to school or stay in school due to I'm attributing it often to anxiety, and autism and anxiety go hand in hand. Anxiety, a lot of other students who don't have autism obviously also have anxiety. And I'm seeing a lot of situations where students are having trouble getting to school, they don't want to go to school, or they don't want to stay in school. Or the behaviors are such that the districts are saying, hey, parents, come and pick your child up. That could be because of staffing shortages. It could be because your child is not enjoying school, and they're, for whatever reason, they don't want to go. Maybe somebody hit them, or maybe like another peer because of their behaviors. Maybe they don't like being yelled at, or maybe they just have had, one thing happened and they can't overcome it, or maybe they really like being at home with their parents. That's also a very likely possibility. But either way, I'm seeing a lot of situations where students are not in school for the full day, and with some capacity or another. And what I would suggest to you is that school districts do have an obligation to develop a program that enables your child to be in school and receive their education just like everybody else. Okay. So if your child is not in school and not getting an education for the full day that they're entitled to, accommodations or modifications need to be made to make that happen. Either they need specially designed instruction in the home to get them to go to school. It could be that they need extra support. Parents might need extra support. Parent training could be something they would be entitled to. It could be that maybe a student needs extra support in school they need to do a functional behavior assessment to figure out why are they engaging in behaviors that they're sent home from school. But the behavior itself needs to be assessed and the proper instruction needs to be provided. So I think that's a really key trend that I'm noticing, that I wouldn't just accept if the district is calling you to pick your child up. I'm afraid of establishing the trend of saying that's okay, because then the child will then repeat. If they really want to go home, they might repeat that behavior or that increase that behavior to get what they want, which is really to go home. So I would just watch how that behavior is being addressed and make sure that the appropriate supports are there to provide necessary instruction to make sure they're in school as much as they can be.
Wow, that's really good. So my last question, and I know we're getting to the top of hour, and it's certainly okay. I'll let you answer ask your question since mine is shorter.
Hi, sorry. So my question just came out off of what Hillary just mentioned about picking a kid up from school and all that. So we've had that a couple of times in the last school year. We haven't had that at all this school year. Thank God for that. But the thing is, so when they call, okay, Janelle is this, she's having these tantrums and all that. And then we ask them, okay, what have you done? It's typically like the nurse that calls, first of all. She tells us, okay, this is what happened, that's what happened. And then I'll be like, okay, do this to this to that. And then they go, okay, fine, we're going to implement that. If it doesn't get better, we're going to call you back. And then they go, and then the next call is like from the nurse and the teacher, right? And so, they explain it. And I'm just like, okay, you guys, try and manage this, the behaviorists, have they done this? And then finally I'm like, okay, give me 20 minutes, I'll be at the school. So I go there, I pick Janelle up, and then she comes out of the door and she's smiling. And in my mind, I'm just like, you guys, I told you this and all that. But the thing is that it's I'm sure it goes on record that Janelle was asked to be picked up, and then her mama, came and picked her up, right? So I get it with the trend, that it's not a good trend, right? But in I'm not trying to like make a case for them, but when I spoke to my husband, we were like, okay, in their defense, they don't want, Janelle, self-injurious behavior to actually, hurt herself while in school. They don't want to be responsible for, that if they have trust, quote unquote, if they have tried their best and there's really nothing else that they could do, the next thing is for them to call us. And that's what they do.
I'm
So
gonna,
I'm like,
I'm
what
gonna
happens?
because what happens is that it's their obligation to there's always something else that they can do, right? If they don't have the right staff,
Mm,
then but they might not know what the next thing to do is. Of course, the first and foremost, the student should be safe. Okay, if
mhm.
they don't have the staff to work with your child to make sure that they're safe, then yeah, maybe you just pick your child up, because your
Okay.
first and foremost safety is important. But if it happens more than once or more than twice, then you should be asking for an IEP meeting. What are we doing about it? Um,
Mm,
if if they don't know what to do, the solution is not to send your child home. The solution would be to either bring in a behaviorist to work with your child,
mm,
or if they're not doing that, or the behaviorist can't meet your child's needs, then maybe they contract with a different provider who can evaluate your child, another behaviorist who might
mm.
have better ideas. Or that's when you talk about an out of district placement. But the solution is not for you to keep picking up your child. It's an interim step if your child is sick, if
Mhm.
it's absolutely necessary to make sure that everybody is safe. Because I emphasize this to the nth degree. Safety and health are the most important.
Yeah, okay, thank you. And then sorry, and I know we're running out of time. but the behaviors that they have there, like, is contracted to maybe like 2 other schools. So she's there, and then she's not there, and then she's there. So are you saying that this is proper grounds to request for an out of district placement if it happens often?
Potentially, yeah.
Okay, okay, all right, okay. Dr. G, I'll get back to you on that. Thank you.
Why did you think I asked that question? So
Yes,
that led,
I know
because
you asked it for me.
yeah. So I think that was going to lead to my last question to you, Hillary, is that when is the appropriate time to consult an attorney? Because some of us have had to do that. I know the first time to get Nick out of placement, out of district placement, it was it was just that. And then realizing that we have enough data to suggest that they couldn't provide us the level of service that he needed in district. So we've gone through the multiple processes. So I'm not in any way here telling everybody go out get an attorney, but when is it valuable from the mental health of the parent?
Just that. Um, if you are in any way not confident in the child's program or your child's progress, I would consult with an attorney. You don't always have to hire the attorney right away, or at all, but I would consult with the attorney to maybe bring clarity to the situation, to help you either develop an action plan on moving forward, or take over if the circumstances require it. So, and that's a decision that you make together with the attorney. If you say, look, sometimes I definitely have consultations with people, with parents who we just go over the records, we go over an action plan, but I tell them I don't think you should hire me now. I don't think I'll be helpful, because I don't. There are some things that you can do yourself. Sometimes though, when basically maybe what I go by experience and what has happened with this family already, if they haven't been able to get what they need, then I might step in sooner and go to an IEP meeting or sue the district. Other times, like I said, if the parent has never asked for anything, then I might say, hey, parent, why don't you try asking for this first? And before I get involved, to see if it works out in your favor. The idea around education and special education is they're important to remember two things. One, just because you have a child with disability does not mean that you are automatically the expert in your child's disability, just because you're the parent. It is a learning process. You will ultimately become the expert, of no doubt. I also have no doubt that you know your child better than anybody, but there are experts and professionals in the field that can help guide you. So the quick answer to summarize that question is, if the district has said no, you might want to consult with an attorney. Or if you're not sure, if you're not confident in the program or that you're understanding the process, it might be a good idea to consult with an attorney to help explain it to you, and then you can decide how you want to proceed depending on what your needs need to have happen.
Excellent. Thank you so much. Okay, Ronka, get the last question and then we have to release it. She says she will come back. I mean, this was just so good.
You know I'm always here for you.
All right, so thank you. So yeah, I want to ask, I don't know if you've touched on that on 504 plan. When is a good time to request for a 504 plan?
If you said your child has an IEP?
Yeah, I'm looking to request for a 504 plan for my daughter because I see that's not the one with the IEP. I see that the grades are not pretty good enough. Yeah, so I want to see if there will be a need for a 504 plan or if they can have some kind of intervention in place, but no one is agreeing to the intervention. So I'm thinking maybe the 504 plan might be faster, but not the IEP.
So I'm going to give you a general answer because I don't know your child or their disability. So
Okay.
and I don't want you to say it right now. So, generally speaking, if your child is suspected of having a disability that is adversely impacting their ability to learn, then if they require accommodations and modifications, such like extended time, an extra set of books, like I mentioned earlier, then I would ask that to have them be referred to the to the principal for a 504 evaluation and maybe a 504 plan. Principal or guidance counselor, depending on your child's age. If, on the other hand, you think your child needs specially designed instruction, so the instruction is tailored for your child, and then I would be probably having them referred to the child study team to be evaluated for an IEP. Okay, so if your child has dyslexia and they require like Orton Gillingham or Wilson instruction, that's more specially designed instruction than the general education program. So that would just be an example.
Okay, thank you.
You're welcome.
Hillary, the last question and follow up to that. Is there a requirement to see a clinician, a physician, or a provider to provide some medical reason for that, or no? For that, based on what she just asked.
No, for a 504 plan, under Section 504, you have to have a disability or have been regarded as having a disability. So if it's pretty clear like that your child is having, I'm going to say attention challenges, right? And everybody really knows that. Then it's not required that they have medical documentation, but it's always a good idea to get it because then there really can't be any dispute that your child has a disability. The follow-up question would be, what is the impact on their educational experience
Okay,
or their
great.
ability to learn?
Wow, this has been amazing information that you've shared with us. I hope the folks that are listening in, you found that very helpful, and hopefully that empowers you to know how to really advocate for your loved one. We ended up doing it as a Q&A, which, flew very, very nicely. So certainly if you have any comments or questions, please email us at info@mygoalinc.org. We can get it over to Hillary. And Hillary, if somebody wants to consult you, what states are you? Do you provide
So
licensed in? Yeah.
I practice in New Jersey, Pennsylvania, and I do have a few cases in Nevada lately. So I usually consult with attorneys in other states, but at my offices and primary practice is New Jersey and Pennsylvania.
Right, excellent. And then I know we focus on schools, but other areas in special ed law or special needs law that we need to know about that you
Yes, you should absolutely. As your child is aging and getting older, you should really be paying attention to eligibility for SSI, Medicaid, whether guardianship is necessary at 18. You should look to whether if your child has a developmental disability, then you might want to think about whether your child will need adult services, in which case, like through DDD or DVRS. In which case we should really be talking to plan for that. It's not, that part is not an expensive process by any stretch, but it's confusing. So maybe a 1 hour meeting, and with anybody who specializes in this area will be able to provide that information to you.
All right, excellent. That just goes to tell you that importance. And then now to the last statement that you just made, what age should that consultation begin? Is it 18, 17, 16, 15? When?
I would say that if your child is going, if your child is going to be in need of DDD services, you should plan that they're going to be in school until June following their 21st birthday. So I would plan for the adult services around 18. If you're going to need a special needs trust, I would plan on that sooner, as soon as possible, because you have to do that before you pass away. And God forbid that anything happens to you, you just don't know when that will be. But in terms of planning for adult services, I would say around the age 18, that would be a good starting point.
Okay,
To kicking that process off.
wow, so it's a lot. It's a lot for families. It's one thing to just navigate through the school education. And like Okwe said, I can't tell you how many parents get the calls all the time, come pick up your child. And the same reaction, you did an amazing job not reacting visceral like I do. I can't hide my feelings about that. But I
Be that compliment before.
But that seems to be a very common trend, and obviously people are concerned about that. So I really appreciate your feedback, your response there. And so if you're a parent and you're listening, please know that we really want to make sure that your child gets educated. And the goal there is for them not to come sit at home and just watch TV and be on because that's what even every neurotypical child wants to be at home. They don't want to go to school. So we definitely don't want to encourage that. But thank you so much, Hillary. This has been fantastic. We will definitely have her back. You have questions, comments, feedback. I'm sure she'll appreciate it. And like I said, you can find her on freemanlaw.com.
FreemanLawOffices.com.
FreemanLawOffices.com. So thank you so much once again. And if you have a particular topic of interest, do email us as well too, and we'll definitely reach out back to you. So once again, Hillary, thank you. Really, really appreciate it. And for all our listeners, next month in December, we're going to have a holiday party instead of the Ask the Expert. So if you're in New Jersey, December 8th, we will be having a holiday party. So look out for that information. And if you're not on our email list, email us at info@mygoalinc.org and we will add you so you get to hear everything that we're doing. So on that note, thank you so much, everyone, and have a fantastic evening.